the forecast of that evidence, if that was true, I wouldn't be asking you to sit and listen to the real facts of what happened in this case. This jury system where the state presents evidence that they've been given by law enforcement and witnesses, cross-examined by the defense, this process where you hear both sides and the evidence cross-examined, that is how we get to the truth. I will start with the story of the projected evidence in just a minute, but the untruth number one that has been forecast is that Craig Blitzer came to me before he ran for office to ask me anything about hiring my wife. In fact, this whole theme that somehow I had my wife working with me for income is false. In order for you to understand the decisions that I made during this time frame that he has projected, you need to understand what led up to that. I ran for district attorney after being a criminal defense attorney for 20 years in private practice, successful, winning cases with my wife working with me, raising 7 children. This is about a different geographical area. I don't know if all of you grew up here, but I know all of you have a sense of home, where you grew up, what you consider your home, where you're raising your kids. That's where we were in Roxborough. Pam had been there her whole life. I grew up next door in Granville County. I believe one of you sat on a jury in Oxford. But we were there raising our kids, and as I'm in private practice, this is what I see. Our violence, drugs, gangs, over 100 open-air drug houses, shootings almost every week, was invading our county, our home. Gang colors were in our schools where our kids were going. At one time, we had kids in preschool, elementary, middle, high school, and college. And as the violence and crime was continuing, what was happening in the courthouse, which is much smaller than this courthouse, was the state. Low morale. The DA's office, and Mr. Latour is an excellent prosecutor. Low morale. The 8-to-5 mentality. The state's losing 7 out of 10 cases. District court is overrun with 100 people left at the end of the day. And the elected DA is at the golf course. And that's the environment that we stepped into when we ran for district attorney. It wasn't about money or having Pam come and supplement an income. It was about a promise to the people that I ran and was elected with that I would bring my private practice, my office. I was winning most of my jury trials to the courthouse to change things. And so we did. And as we did the transition, I knew I had to ask the question. We had an orientation in December 2010 with Peg Dorr and Margaret Wiggins to get oriented as new elected DAs. I'd never been an assistant DA. I ran because I wanted my hometown to be safer. I knew that in order to get control of the violence and make crime go down, you had to have an effective trial team in court. Because if the state is not winning cases, then plea negotiations, there's no value. And the kids in these neighborhoods were choosing the gangs as opposed to an education another way. And I saw it. This isn't a box of papers that I learned from some officers or other witnesses. We were living it. So we went in. Previous administration had most of their folks that lived outside of Person County. All of our administration lived in Person County, except one who grew up there. We set new systems in place. You will hear from senior resident Superior Court Judge Osmond Smith, who I met with and completely redid our Superior Court case management plan. We redid district court so that instead of 100 people at the end of the day and officers who come in and sit in court all day long, most of our cases were done by lunch, maybe 1 or 2 trials in the afternoon. Things started changing. We partnered with law enforcement, started doing undercover drug buys, camera buys, not charging for 6 months, going into these neighborhoods overrun by drugs and gangs, and then do the arrest at one time. 100, 120 people. The gang members, the drug dealers, rounded up and prosecuted, and I was not sitting in an office as an administrator signing papers to lead my team. I was in the courtroom trying cases to reclaim the courtroom. And the evidence will show I did over 70 jury trials during this time period and lost 2. Law enforcement and the DA's office were back in sync. They were working. And simultaneously, we were implementing other programs like the redemption program, deferred prosecutions, so that young people weren't getting their first convictions. And Pam was part of that. Now I know AOC exempt employees, you're going to hear regulations that if you work over 40 hours, you have to get time and a half. That law I broke. I worked 60, 70, 80 hours a week. She worked 50, 60, 70 hours a week. This was not about an hourly rate or punching the clock 8 to 5. This was about our home and changing the crime rate, the reports that we had seen in Durham most of our life. Now we're at our doorstep. In the first 4 years, we accomplished that with law enforcement, with these new ideas, with these new programs, for a 36% reduction in crime. Back to the beginning. When I'm at orientation, I asked, is there any policy or regulation that prevents me from hiring my wife? Peg Doris said, I don't know, but I'll check on it. The next day, she comes back and says, AOC says there's no policy or regulation against it. We don't recommend it, but it's not against the law. So, we plan on not just her, but other members of my office coming into the DA's office to fulfill my promise to the people that I would bring my private practice and private enterprise philosophies and principles to the courthouse. And yes, I retained some of the folks that were there. But the 8 to 5 mentality and the hard work ethic and the morale changed. And I'll tell you a couple other policies in just a minute. I want to stick with my wife's approval by AOC. When I was sworn in and had the team get sworn in, just to be sure, I waited a few extra days before actually hiring Pam. I had another member of my staff, Luann Martin, call AOC and a couple of other agencies to confirm that there was no law or policy that prevented Pam from being employed. And she was told independently from me, and she will testify to that here, that there is no law or policy against the hiring of his wife. In fact, she'll say, are you sure? She will tell you that. So this notion that, oh, well, the people in the county knew what was going on is only part of the story, just like you've heard part of the story. AOC knew, and we contacted state officials and were told she could work for me. And again, they said, because I was a constitutional officer and not subject to the State Personnel Act. And that's what I was taught and trained. And we went to work. And all that, during that time period, judge after judge after judge rotated through that district. My senior resident Superior Court judge, Osmond Smith, worked with Pam almost weekly. Every 6 months, judges rotate in. She had picked my juries and worked with me in trial. She was one of the reasons why I was successful in private practice and why we had 70 jury trials with only 2 losses when I was working for the state. Every judge that came in is introduced to Pam as my wife, and yet AOC, nor my resident Superior Court judge, nor any other judge that rotated in, even on the state ethics form that this ethics commission that's been referred to, it's disclosed. The state knows that because that's in their discovery where they talk to each other and say, they even disclosed to state ethics that it was his wife was working for him. Can you believe that? Another thing that you need to understand, because we'll ultimately be talking about an investigator slot. So I campaigned on an investigator being a law enforcement officer because the previous administration had an investigator slot that mainly did discovery and case prep and things like that. There's a gentleman, David Ramsey. Bailiff reminds me a lot of him and how he runs the courtroom. David Ramsey retired from the Roxborough Police Department. He then worked as a bailiff for the Sheriff's Department where he retired. And when I became DA, he became my investigator. And my senior ADA, Holly McAdams, and me, and Pam supporting, picking juries, along with David Ramsey, who knew everybody, who could find any witness I needed, well respected in the community, and a great gospel singer, by the way. We were an almost unbeatable team. And again, it wasn't about hours worked. I promise you, over 40 hours were worked every week. Because the culture in private practice is every Sunday night, you're in the office working, getting ready for court the next morning. When you had to stay late at night and do trial prep, you did it. But we not only did that, we had community programs with local mission trips and other things I will get to. But I do want to mention one program as a forecast of our evidence before I get into the second phase. I made decisions, administrative decisions, that were different than the normal AOC guidelines, and they've got a job to do. They have certain procedures in terms of documenting hours. But I saw the morale problem of mothers and fathers with kid issues and sick issues and all this calculating, trying to use vacation time and things like that. I wanted them focused on working for the people. So one of the policies I put in place, right or wrong, was a kids first policy. That meant anybody in the office had any issue with their kids. They were sick, they had a school project, they had to leave early for a soccer game. If there was an event at school, there was a policy that employee got that time off and everybody else covered. And just to let you know that I did the deep dive, I did that not only under my authority as district attorney with certain constitutional powers, which you'll hear at the end, you'll get the law. But also AOC had a little line, other approved management leave. Any other leave that I deemed beneficial to the office. We had one of the offices dedicated to be a child safe room with toys and books and television for child victims, but also every employee had their kids in the office. Anytime something came up with their kids, they were given time off to go do that. That was the culture of our office, and morale was great. You'll hear about other programs, but I tell you that as I go into the second term. David Ramsey, who was my right-hand man, in the fall before the second term, suffered a stroke. He had partial paralysis. He couldn't speak. Almost died. So, as we watch him recover, I watch the bureaucracy of state government. You have to use all your sick time and all your vacation time. And unless you get somebody else to donate something to you, you're just out of time. As that time period approached, they didn't know what to do. I had told you he retired from the PD. and he retired from the sheriff's department. And then he needed 5 years to vest with the state. So I met with him and his wife. The paralysis was getting better. He had gotten his speech back, although it was slow. And you will hear evidence, hopefully from David and others, that we decided to adjust his duties to be on the front desk, to go in a different slot so he could finish out his last year. There were 6 murder trials pending in Caswell County. He has forecast to you this is a 2-county district. We had had a successful run with 36% reduction of crime, and I'm trying to figure out a way to move it 36% more. David's down. The hardest working support staff person who's willing to work 60, 70, 80 hours a week is my wife, who's been with me in private practice and there. So I talked with my team, my senior ADA, AA, and I made the decision to basically have Pam move up and take 2 jobs. To try to do all the responsibilities of the investigator, because she's going to be in court anyway, and the victim witness legal assistant job, and help out now in Caswell. And there's a document that I did to AOC that I'll present to you in evidence so that you can see what was sent to AOC. There was a reference about a pay raise to my wife. And this truly is a tale of 2 cities. Because the motive that has been forecast from the state, I would contend forecasting to you evidence from the defense. This was not a motive for nepotism and increased salary for my wife. It was a way to deal with the situation generated with David's stroke and workload allocation. I'll go ahead and tell you, all of this is not wine and roses. You will hear evidence I've made mistakes. One of the mistakes I did in the allocation of salaries is I did not give a raise to Debbie Hallbrook in Caswell County, which I learned subsequently she became very bitter about. And she saw the raise to Pam, which she became bitter about. And another ADA based on performance, I decreased the salary. Did it all in consultation with my team, meaning my senior ADA and AA. We sit down with the chart. Why did I have to do that? Let me tell you, forecasted the evidence. When I took office, and I know this will be a little complicated, so I'm going to try to make it simple. ADAs are paid by allocations. When I took office, I had 6 allocations, but the legislature had frozen 1. But Judge Smith, director of AOC, had approved the use of that allocation for 6 allocations over 5 ADAs. Well, by the time I got to the 4th year, the legislature had eliminated that allocation, which meant I had to adjust ADA salaries. I had 6 pockets of money spread out over 5 people. And now that, I think it was around $70,000 allocation, went away. So now I go into the second term, trying to cover for David, put him on the front desk. I've done salary adjustments that where I had to cut, I cut with who I considered to be the least effective DA, not a bad person. It was a management decision, but it created hard feelings. So now, we're going into the second term. Remember I started with untruth number 1. That Craig Blitzer came to me before he ran, and I said, oh, just hire your wife. I contend the evidence will show in conflict. That's not true. So in terms of my familiarity with Craig Blitzer, I do believe the evidence will show I had been involved with him one time many years earlier where he was representing a first-degree murder client by appointment, and I was defending a first-degree murder client by appointment, and they were co-defendants. We were not friends, we didn't know each other, we worked together on that case. After he won his primary, he did come to an event that I had in Roxborough and showed up and came up to me and was with a bunch of other people. I was running unopposed, and he said, "Hey, do you have your wife working for you?" And I said, "Yes, AOC approved it." There was no encouraging him to run. That was after the fact. So I start my term a little bit handicapped from the first and trying to improve on that crime reduction. And I get a call from Craig Blitzer. He says, "Hey, AOC says I can't have my wife. I was at orientation in December and told them that I wanted my wife to work for me. They said it was okay. I hired her and they said it was okay. And now they're calling me and telling me I can't do it. How are you doing it?" That's what happened. And I said, "I don't know. AOC approved it." And at that point, I was told about the State Ethics Act from AOC. I believe passed in 2006. I will put on evidence about the constitutional authority of district attorneys that have employees that serve at their pleasure and that have authority, complete authority over the supervision of their employees. However, despite that law, in 2006, the legislature passed the State Ethics Act, and part of it, within it, was about supervising a family member or causing an effect of employment of a family member. And you did get a forecast, and I won't go into all the details, but you will see the emails from Margaret Wiggins where they apologized for not telling us. And you will also see that as a result of this lack of knowledge by the administrative office of the courts that ran all courts in the state of North Carolina and was responsible for every employee in the state of North Carolina in the judicial system, somehow did not know about this provision in the 2006 Ethics Act, nor did any of the judges that had rotated in for the last 4 years. So I look at it, and you'll be presented it. In the 2006 Ethics Act, they had this little paragraph that was applied to all judicial officials and public servants, except, guess who? The legislature. Legislators were exempt, and they could still hire their wives and family members because it was a tradition within the General Assembly. So they passed this law, exempted themselves, and now I have AOC saying, "Oh, we think they should have to resign immediately." So those are the cards that I'm holding now. At this point, I contend to you that evidence will show that Pam Bradsher is not a nepotism figurehead wife holding a slot just to get a salary. She is an essential part of a team and just assigned to do 2 jobs while I have David Ramsey down. And I'm just being told about this now. Remember, I'm not just in an office administrating. I'm trying cases in Superior Court. I'm helping out in District Court. I'm going back and forth between 2 counties. I've got 2 chiefs for each county. And I'm trying to figure out this allocation of resources. But flaw number 2 that you will hear, I think I can solve every problem. You will hear things throughout this where I attempt to solve problems and I made a mistake. You're going to hear that. And this is one. As I did at the beginning of my administration and throughout the first 4 years, every time that I had an issue, I went to my senior resident Superior Court judge. And I would go talk to him, say, what do I do? because the administration of justice required everybody. That's why I created a stakeholders meeting. Once a month, we all met. Me, the resident Superior Court judge, chief district court judge, probation officer, clerk, to see things, improve things. Wanted to make it better. So I showed him the act. And in the act, if you're found in violation, it goes all the way up, and the last person of appeal is, guess who? The senior resident Superior Court judge. So I talked to him about this. I wonder if I could get screening where it says supervise. Maybe if I put in a screening thing that you sign off on, because you're the ultimate judge, then I can get Pam to be here. So he said, okay. So I talked with AOC, proposed the switch. That's the other thing. I'm going to produce emails to you that AOC said the transfer of employees was okay. Said, sounds like you found a good solution. The attorney for AOC was involved. So this notion that there was a wife swap for no-show jobs, a wife swap for no-show jobs that was hatched at a pizza place in Rockingham is untruth number 3. The approval of AOC to transfer this as a temporary measure for us was done right there in the office. The trip to Rockingham was after the decision was already made. The evidence will show that meeting was because she was going over there to get acquainted with the courthouse where she was going to be working until hopefully the State Ethics Commission approved this plan. And I'm going to show you evidence that after getting approval from AOC on the switch and my resident Superior Court judge talking to him, that I did a letter. First of all, forgot. Before all this, Margaret Wiggins with AOC, when they first told us about the policy, said, and this is confirmed in an email, you'll see the evidence, said, oh, sorry we missed this state ethics thing, but just call them and get a waiver. So stupid me thought, oh, well, this is the Administrative Office of the Courts. Margaret Wiggins works directly with Judge John Smith, the director. They say get a waiver. So I called to get a waiver. And I spoke, who's also on the witness list for the state, Kathleen Edwards, called and told her everything I just told you. And said, AOC said I should call to get a waiver. How do I apply? And the answer was, oh, there's no such thing as a waiver. So I talked with her at some time, and I am told I can try to get an advisory opinion. So I've talked to my judge, talked to state ethics, I've talked to AOC. We're going to transfer the positions, and then I'm going to send to the state ethics my proposal for an advisory opinion on this screening plan with 2 theories. One, the DA's office and the district attorney has this constitutional discretion to run their office. And it says supervise family members. So if there's not direct supervision, then perhaps with a screening plan approved by the judge, it would be acceptable. So I did that. Pam went to Rockingham to work. Cindy Blitzer started coming to Caswell County to work. I assigned Jay Stoltz to supervise Cindy Blitzer because he was the chief of Caswell County. And we went out and bought a small car for Pam to drive back and forth to Rockingham County. And she continued her excellence in work. And you will see evidence to that. I am sorry that this is a long story, but it's important that I forecast the evidence to you so that you can follow this roadmap to the end. Because the state's forecast of this roadmap is different and gives a different impression than what happened. So I send it off and we wait. I go back to trying cases. In May, get a letter back with a formal opinion from state ethics that says we cannot give judicial officials an advisory opinion. The same legislature that had passed this law and exempted themselves so that they could still hire their wives because they deemed it beneficial to their office. I understand that. Had left out a way for judicial officials to get an advisory opinion. Says that we can't. In this time frame, Pam starts looking for other employment. In June, Kathleen sends me a letter that says, we can't give you a formal opinion, but here's our letter of guidance. This is at least mistake number 4 on my part. In that letter, she says, essentially, and I'll show you the letter, don't think you can do this even with screening because as the hiring authority, district attorney, you have ultimate authority over all employment-related activities. In other words, for the purpose of the State Ethics Act, I was the ultimate supervisor of people in my employ. Wish I'd have just stopped right there. But again, my flaw. I think I can fix any problem. So Pam transitions to work for PCC in August. During this time frame, there was only one silver lining in her going to Rockingham, and that was best practices. You'll see emails where I even wanted to order the carts they used in court. But they also did paperless discovery. Now, all of you, very intelligent. I know you have IT training more than I could comprehend. But they were not receiving any paper discovery. It was all digital. And the biggest workload issue in the district attorney's office was paper files and paper discovery. If any of y'all ever been to the doctor now, you know everything is, it's all on that screen, digital, it makes compilation of medical records, etc. So we started implementing that, and you're going to hear that for the last couple of months that Pam was working for, she transitioned, she was doing that work in Person County. And Cindy was handling conflict cases and work in Rockingham County. We were basically doing a shared employee arrangement. Pam goes to another job. Well, should have just let Cindy go, right? Craig Blitzer says she needs to remain employed, but she's working mainly in Rockingham. I'm trying to figure out how to assist this elected DA, because you will hear evidence. This is right from the state. She said she needed one course to get back and finish nursing school. And you're going to hear evidence. I went to my local PCC asking to try and get her into that program and did not succeed. And so Pam's leaving me. I still got I still got David Ramsey down. And I have this other elected DA that I've agreed to take conflict cases for. And I've got this issue, and Kathleen Edwards has given me the answer. If I am the ultimate supervisor, then can I base Cindy Blitzer in Caswell County? In Rockingham County to do work? Talked to 2 other elected DAs. They said yes. So here I go. I need to back up just for a minute so you can understand the context. Criminal defense lawyer for 20 years. When I transitioned into being DA, I had 200 conflict cases, meaning pending cases I couldn't prosecute because I had been their defense lawyer. So I had other DAs and ADAs from other counties come in and handle my cases. So I gave a like-kind exchange. So in addition to everything I've told you I was doing in 9A, I was handling 30 conflict cases in Halifax County for Melissa Pelfrey. I was handling conflict cases for Mike Waters in Granville County. I was handling conflict cases for Roger Eccles in Durham County and Pat Nadowski in Alamance County. And now with this newly elected DA, Craig Blitzer, he also was a defense attorney, and I agreed to handle conflict cases for him. So I came up with the shared employee idea. Cindy Blitzer was going to be helping with conflict cases. Craig Blitzer also gave me a first-degree murder case, actually started with Jay Stoltz, of a young baby death. So was I going to take a legal assistant from Person or Caswell and have them go over to Rockingham all the time to do this prep work, conflict cases, etc.? Or was I going to use the shared employee program to have her there to do the work? So I talked with Jay Stoltz about it, talked with Craig Blitzer about it. The shared employee program, there's actually a statute that allows the transfer between two agencies. And I was trying to make a way that this worked from a use of resources allocation. And this was the plan. Tyler Henderson was my computer guy. He knew the computers. We were already adopting Rockingham's plan on paperless discovery. So my vision was to use this time temporarily under the shared employee program to have Tyler develop a system that could be used statewide, which involved paperless receipt of all discovery, ultimately to paperless files. I called Peg Dorr and said, is any other DA's office doing this? She said there were a couple that were trying, but they hadn't perfected it. And it would essentially change a big file room of paper files into a file drawer of zip drives and CDs. I even talked to Judge Marion Warren, Director of AOC, about this and at Oprah. So Tyler was going to take the system from Rockingham, develop for Person and Caswell County paperless discovery into paperless files. And I know none of you, it doesn't sound like you worked in the DA's office, but we had the old paper files and people were bait stamping page by page by page and converting this discovery to digital discovery. Not only helped us internally from a manpower standpoint, but if you wanted U.S. attorney to look at a case in my county, you loaded the car with boxes and you drove to Greensboro. Under this system, you sent an email. It also provided greater accountability. Officer says he dropped off discovery. There's an email chain. There is a way to verify. So Tyler Henderson, under the shared employee program, he became a Rockingham employee based in Person and Caswell. Cindy was an employee of my office based in Rockingham. Her job was to handle conflict cases, do special projects that I had given her, I'll tell you about that in a minute, and any overflow work from Rockingham. Now I want you to understand this. Cindy had an office in the Rockingham courthouse. I had seen it. And I have seen emails that they did work on that office in as late as April or May after the switch. Jay Stoltz was her supervisor. So in my mind, she's there under the supervision of Jay Stoltz. Tyler is here processing our discovery and implementing the system. I'll say one more thing before I leave that, and then I'll try to move on. Even though AOC had this email system for discovery, if you had more than a 1-minute video, it couldn't go through the internet. So they were sending the paper discovery through the email, but still coming to the office with these exhibits, with CDs and things like that. Our goal was to get it all digital. So Tyler met with the Sheriff's Department. You're going to hear from the Person County Sheriff. We went over and tried to establish drop boxes, things like the undercover buy camera where it could be accessed all digitally. Person County participated, got up and running. Roxborough PD participated, got up and running. And when we turned the corner on 2016, we began paperless files in Person County. Unfortunately, Caswell County, where Jay Stoltz was chief, Debbie Hallbrook is one of the holdover employees from the previous administration, who I believed had been there for 20 years. She was the primary legal assistant that accepted discovery. And let me tell you, the evidence is going to show the defendant has an absolute right to all their discovery. There are cases, you read in the paper, they get overturned. Guilty people set free because discovery violations. Having all the discovery and turning it over to the defense is fundamental to the fairness of the process. So as I'm going into the next year, I tell Jay Stoltz that I will come perform the Caswell chief duties because he is running for judge. And when I go to Caswell to do the transition, I come into the Caswell office and I find not a good situation. Over 100 paper files on the top of the file cabinet, files with discovery in disarray, and more importantly, co-defendants that are supposed to have identical information out of fairness have all different information. Information that officers said that they had left that are not in the office. So, got to know me, my management style. I'm busy all the time, but when I see something like that, you will hear evidence. I called Person County, said send 3 people over, and we started cleaning up. And as we got everything filed away, it was obvious that all of the pending felony files, we were going to have to do an audit. And I said to Debbie Hallbrook, what in the world? I mean, she's been doing this 20 years. I did not expect this. And her response was, well, it's Jay. I said, I understand he has accountability. He was the chief over here. But you've been doing this for 20 years. I don't understand. You know better than this. I did not understand. I knew then I had to get this electronic system up and going in Caswell County. Person was on, Roxborough PD was on, bring Tyler over, and I meet with Scott Hallbrook. This is Debbie's husband, who is second in command at the Caswell Sheriff's Department. I went to see the sheriff, but he told me to meet with Scott Hallbrook. So I met with him. Summer, July, this is important. July 2016. I said, we have got to get this email discovery up and running. That was important because when everything's in disarray and everybody else is saying, well, I dropped it off, well, I didn't receive it, why? I don't know anything about that. If I have email discovery, I don't need that. I've got independent verification that it came in and that it went out because we gave discovery that way as well. So Scott doesn't say, no, I'm not going to do it. He says, okay, I'm going to assign Melissa Poole to that, who's also on the witness list. So then, go to Melissa Poole. I can meet next week. So I tell Tyler, work with her. I go off doing my other duties. Then she puts it off another month and another month. And I tell Tyler, send her an how-to. And I said, we're not going to accept paper discovery after the first of the year because I can't take that risk. I moved Debbie Hallbrook to Person County, figured it was a training issue, and set her up doing nothing but digital discovery, learning how to do it. She was resistant to it. I said, we are going to digital discovery in Caswell. I have to have that accountability. So then Tyler still won't get any cooperation from Melissa. So I dictated a letter to the sheriff. Debbie Hallbrook wrote it. saying, first of the year, we're not accepting paper discovery. Please implement. We've sent a how-to, etc. Nothing. So the first of the year, they sent 2 packets. We sent it back. I went to my resident Superior Court judge again and talked to him and told him, you'll hear from me, the sheriff will not go to this digital discovery. And I have got to have accountability of what goes in and goes out. I also talked to the clerk of court, who was on our witness list, and told them about the issue that I was having with Debbie and reliability, and I had to go to this digital system before I sent her back. In fact, God just reminded me, specifically at Jay's swearing in Caswell, the clerk came in and said, when was Debbie coming back? And I talked to him later. I said, I don't know that she is, because I have to have a guarantee that this discovery is going through. And then on January 11th, I got a letter from the sheriff saying, I am not required by statute to do this, and I'm not doing it. At that point, I made this decision. I let Debbie go because I could not send her back to Caswell County and trust to receive the discovery. The sheriff was not going to accept it. I could have made a big deal of the fault issue with the files before, but as you hear all the witnesses, I hope you'll find out that was not my style. And so, since she served at my pleasure, I let her go and allowed her to draw unemployment and move on. And again, as I am a performance-based boss, I took a legal assistant that was in a grant position who at that point was out working everybody, came in on a grant, another special project that I had, which was to reduce the jail population. Have like a triage nurse running through every court, through every file, that if there were people in jail on low-level matters, to get them out, get their bond lowered or out. And if there was a dangerous person that needed to go to jail, then speed process their case and let's get it to trial. But don't let people languish in jail. That was her job. And she hustled and outworked to save the county hundreds, I would say $600,000 or $700,000 from just reducing that jail population. I moved her into that permanent slot. The legal assistant that was cleaning up all the files and going through and auditing every file and was doing Caswell County became the legal assistant. Now, I'm not going to get into all the details through here. I'm going to talk generally as Mr. Latour did, because you're going to see as we get into this last phase where they have alleged that I committed these crimes, we're all the way up to the point where the crime is alleged to have occurred April 1st, 2016 through October of 2016 when I let Cindy go. I'm going to tell you a few bright line points on that before I sit down, because I know I've wore you out already. She is under the supervision of Jay Stoltz. When I came in to do the Caswell chief job while Jay was running for district court judge, I said a lot of things to Jay about transitioning his duties to mine. And I said to Jay, when he listed Cindy Blitzer as one of his duties, I said, that's one of the things we need to relieve you from and get you out of his chain of command, out of her chain of command. He took that to mean, I'm done. Unfortunately, I didn't. Then I went on with discovery and running Caswell County and doing the regular duties of the Caswell County chief. And we're going to get into more of those specifics, because along the same time, There's a lot going on in the Rockingham District Attorney's Office among their employees and Craig Blitzer and statements. And at that point, we are under the belief that Cindy is working on the special projects, the conflict case, and doing overflow work for Rockingham where she has an office. That wasn't happening. In fact, Jay had been approving her time in Beacon. Then the murder case, the Shaka case that I agreed to take, it was time for me to look at it for trial or plea. So I went and got all the files the way I do trial prep. It was going to be my case. It was a murder case. I took all of the top cases. I took it back to Caswell. Jay goes on to do his duties. I'm working, doing my duties. And then, remember, to kind of line the time frames up, in July, I'm talking to Scott Hallbrook about the digital discovery. And then in August, I get a call from the SBI that says, we want to come talk to you because we've got information that Cindy Blitzer is getting a check without working. So I call Jay Stoltz. I say, there's an issue with Cindy's time. SBI's call, what's going on? He said, I thought I was relieved of that responsibility. I was like, oh no, I thought that was one we're going to get to. So I'm like, all right, and I hung up. You're going to hear that after that phone call, he called Gail P. and said, Gail, have you been approving the time? And she said, no. He'll tell you, he thought he had messed up Cindy Blitzer's pay. Guess what? From April, May, June, July, August, the administrative office of the courts paid a paycheck without any supervisor's approval. They didn't do it. And before I get too deep in that, watch for that evidence as it comes out. The relationship between the necessity for us approving time versus AOC actually paying the money. Because the truth is this, doing 70 jury trials, being on the North Carolina Courts Commission, going to trainings, going to public events, going to the Conference of DAs, I do not see anybody where I could say they have worked the hours they put in. My administrative assistant, who is based in Person County in a 2-county district, cannot see that everybody is working the 40 hours that they work when they approve the time. It is an administrative decision to approve the time. You even heard it in jury selection. There's a gentleman that approves his workers. There's an EMS worker that approves 117 people. You will also hear evidence that I asked Judge Smith, who's our senior resident Superior Court judge, the one I go to, his one employee in his office, I said, could you certify that she's working the hours that you're putting down? He said, no, I'm assigned 6 months somewhere else. I'm in court. I have to trust her that she's putting in the hours that she's working. The problem is this, and one of the reasons why I'm standing before you, and I'm going to try to wrap this up in 5 minutes, is we're going to get on with evidence. I want you to know this is not the whole story. And the reason why I decided to stand and have this trial is so we could get to the whole truth. I agree with Mr. Latore. This is about public trust and public monies. But I don't look at it as narrow as these 6 months of Cindy putting in hours she didn't work. I look at it as broader than that. And part of the evidence that I'm going to put on to you is that the offense date alleged is April 1st, 2016, and you just heard about my first term and second term, and I didn't put you to sleep. The SBI was notified by Lee Farmer about the transfer of wives in May of 2015. And nothing was done. No call to say, hey, there's been a complaint. Is this legal? Did AOC approve it? What? And that's not it. Jason Ramsey, an ADA from Rockingham County, who you will hear testify, went to the SBI in December of 2015 and said, Cindy Blitzer is not working and she's getting a paycheck. No one, this is at a time when Jay is still supervising, before the changeover, no one calls the hiring authority that she works for and says, there is an issue. What's going on? And then nothing apparently done until March or April of 2016, where Jason Ramsey goes to them again. This trial is about a bigger truth and a bigger issue of public trust and public money than a misunderstanding about timesheets. Because you're going to hear evidence. Craig Blitzer, this wasn't him taking responsibility for what he did. You're going to hear it in just a moment. He not only did this, nor made these misrepresentations to the SBI, nor did a bunch of other things that I will bring out on cross. He had an assistant DA in his office take an algebra course for his wife during state time on a state computer. And then he got a victim witness legal assistant to take another algebra course for his wife on state time on a computer. He took a federal grant employee with him to BLET for 6 months when he wasn't even in the office and was in BLET. His office during this SBI investigation was wearing the SBI out about things that he was saying and doing. I will contend to you in the evidence. Craig Blitzer was very complicit in a number of crimes and had every motivation in the world to say, oh yeah, Wallace Bradsher encouraged me before I even ran to hire my wife. You will also need to look at the investigation. Because I stand before you with no apologies as to my role in the investigation. In fact, I stand before you laying it all out, where you hear all the facts as it's cross-examined, and I'm putting my fate in your hands. Because a person in my position does not run from danger. It's my duty to stand before you and be accountable for what I did. But I want you to know the whole truth. And that whole truth includes SBI agents taking statements and not putting in half of what you say. And I'm going to point that out to you. In fact, in the second meeting with the SBI agent that I met with, I even expressed concern, and it's not in the report, but I believe he will tell you I said it. I said, Brady material, seeking exculpatory evidence, interviewing witnesses that you're being told to give you the whole picture is your duty. It is your duty. And the response from the agent with Agent Wheatley said, thank you, Mr. Bradsher, for the academic discussion, but we know our duty. And I said, I am the elected DA for 9A. And this is not just an academic discussion. That's the law. And after conferring with 3 other elected DAs and my resident Superior Court judge, I started my own investigation. And I engaged in conversations with Craig Blitzer and others to get to the truth. And ultimately, I did. And even though along this journey, you will hear good things about me and bad things about me, I will make sure that you get the truth so that you can decide, as Mr. Latour will advocate at the end, whether or not to vote guilty or not guilty. But one thing must be done. The judge has told you the law. You took an oath to do your duty. Do not think about the narrow duty of following the law and the Constitution, public monies, public trust, just within this box of April 1st through October 24th. Do it for the whole time period. Because when the judge gives a jury the law, and a prosecutor does his job in presenting, and the defense does his job in presenting, you're very close to justice. But an essential element of that has got to be that when law enforcement starts its investigation, that they're not pursuing evidence to fulfill an end that they expect. It should be instead a search for the truth of what actually happened. Because if it's not, then you as the jury don't see the whole picture. You just see it from the narrow perspective of what law enforcement presents and what the state goes on. I thank you for your time. Thank you for hearing me. And I appreciate you following your duty and following the evidence as it's presented before you. Thank you.